All right, excellent. Let me share my screen. We will get started with, I have so many windows open. Okay, here we go. All right, and yes, please stop me at any point with any questions. So I'm just going to go through the slides, so I won't take time to read over the agenda, but just quickly, the Connecticut Paid Leave Authority, we're a quasi-public entity that oversees the paid leave program. So we are a part of the state of Connecticut, but we're not a full-fledged agency, we're a quasi-agency. The key dates, just as a reminder, the employer deductions began January 1st of last year. The contributions are due quarterly. There is a 30-day grace period at the end of each quarter. So first quarter contributions will be due on April 30th, 2022. And then the benefits became available on January 1st. So we have had some people asking if this can be retroactive. So if they took leave in December of last year, could they receive benefits now? And the answer is no. It was only for qualifying events and absences on or after January 1st of this year. I do want to take a little time to talk about FMLA because the Connecticut law also changed pretty significantly. So while FMLA is not under the purview of the Paid Leave Authority, it actually falls under the Department of Labor. It's really tough to talk about paid leave without talking about FMLA because the reasons that people can apply for paid leave are the same reasons they can apply for FMLA. So just as a quick sort of refresher, there's both a federal and a Connecticut FMLA. And the point of those laws, the Family and Medical Leave Act, is to provide job protection, but FMLA has always been unpaid. So people taking time under FMLA are guaranteed to receive their same job back when they return. But unless their employer chooses to offer some sort of a paid leave policy, like paid maternity leave, they do not have income replacement. And again, Connecticut had some pretty substantial changes that went into effect on January 1st, and I'll get into what those are. So in my mind, you know, FMLA and Connecticut paid leave are kind of the opposite sides of a coin. On one side, you have FMLA with the job protection piece, and on the other side, you have Connecticut paid leave with the income replacement piece. But Connecticut paid leave doesn't provide job protection. And so this is one thing that, you know, we're really trying hard to educate both employers and employees about is if someone applies for income replacement through Connecticut paid leave, that doesn't mean that they have job protection. They have to actually apply directly to their employer for job protection under FMLA. And vice versa, just because they go on FMLA doesn't mean that they're applying for the income replacement part. There's 6 different qualifying reasons that someone can apply for job protection under FMLA and or income replacement. So there's medical leave, which is leave an employee would take for their own serious health condition. That does include pregnancy and serving as a bone marrow or organ donor. There's bonding leave, which is the time someone would take when they have a new child that enters their home. That can be used for birth, adoption, or foster care, and it can be taken at any time in the 12 months immediately after the child's birth or placement. And both mothers and fathers can take bonding leave. Caregiver leave is for someone to take care of a family member who's experiencing a serious health condition. And Connecticut laws do have a more expansive definition of family than just immediate family, which I'll go through what those relationships are. Then we have military caregiver leave. This is caregiver leave, but for a military member who was injured in the line of federal active duty. There's qualifying exigency leave. This is leave that a worker can take if their spouse, parent, or child is on federal active duty or has been notified of a call to active duty. So for example, if you have a couple who the military spouse is the one who primarily takes care of the couple's children and they're notified that they're going to be deployed, the employee, the spouse that's the employee could take qualifying exigency leave in order to make alternative childcare arrangements while the other spouse is deployed, the military spouse. So that's one example of qualifying exigency leave. Then Connecticut also has a Family Violence Leave Act, and that allows a person to take up to 12 days in a calendar year if they're the victim of family violence, and that can be used for seeking medical or psychological care, relocating, attending court proceedings, and things of that nature. So there is a legal definition of what constitutes a serious health condition. So something is considered a serious health condition if it meets one of the following criteria. So if the person is required to have an overnight stay in a hospital or a medical care facility, that would qualify. If they're incapacitated for more than 3 days and they seek medical treatment within the first 7 days of their incapacity, they're under the continuing care of a healthcare professional, and they see that healthcare professional for follow-up within 30 days, that also would qualify. If they have a chronic health condition and they see their healthcare provider at least 2 times per year for that condition, that would qualify. If they have a permanent or long-term condition for which the treatment is no longer effective, that would qualify. That could be, for example, the terminal stages of cancer. Restorative surgery after an accident, where if they didn't have the surgery, they would be incapacitated for more than 3 days. So that might be like surgery for a broken bone or something like that. And then again, pregnancy and the time used for prenatal appointments is also covered under that serious health condition definition. So the reason for sharing all this is that we get a lot of questions about COVID, and someone who has to be out of work because they were diagnosed with COVID and they need that 5 days of quarantine time, is that something that would qualify for paid leave benefits? And the answer is that it's COVID in and of itself is not a serious health condition unless it meets one of the criteria that we just looked at. So if someone has to be out of work and, you know, I had COVID about a month ago, it was, for me, luckily, it was kind of like a serious cold. You know, I took NyQuil, I rested a lot, but I never went to the doctor because it wasn't that extreme for me. Something like that would not be considered a serious health condition. If someone landed in the hospital, or if they saw their doctor and their doctor decided that they needed some prescription medication and then to come back for a follow-up, or if they have a chronic condition that was exacerbated by having COVID, those are things that could qualify them to receive the paid leave benefits. So now let's talk about that caregiver definition. When someone is taking caregiver leave, there's sort of a difference between the federal and the Connecticut laws to keep in mind. When we're talking about federal FMLA, an employee, we have someone else in the waiting room. When we're talking about the federal side, an employee can only take job protected leave under federal FMLA to care for a parent, a spouse, or a child under 18 or over 18 if they have a disability. The Connecticut laws, both Connecticut FMLA and Connecticut paid leave, have a more expansive definition of family. So someone can take job protected leave or apply for income replacement under the Connecticut laws for any of the relationships that you see listed there. So that includes siblings, grandparents, grandchildren, or what we call someone who is related by affinity. What that means is basically if the employee has a relationship that is like one of the family relationships that you saw listed, they can take caregiver leave for that person, regardless of if there's a biological or legal relationship. What does that look like? One example could be an aunt who relies on the employee for unpaid care, and the relationship that they have is more what you would normally see between a parent and a child. That could be considered relationship by affinity. A pretty common example might be an unmarried couple who have a spouse-like relationship. They share a home, maybe they have children together, but they're not legally married, and Connecticut does not have common law marriage. So under the federal laws, they would not be able to take caregiver leave to care for each other, but under the Connecticut laws, they would be able to. So now we'll get into sort of the nitty-gritty about Connecticut paid leave. First of all, who's a covered employer under Connecticut paid leave? Almost all businesses who have one or more people working in Connecticut are covered, and therefore their employees are eligible for these benefits. Non-unionized employees of the state are also covered. And then we do have some exceptions of who is not a covered employer, which I'll let you take a look at, but it doesn't apply to anyone on this call, so we don't have to go through them one by one. Sole proprietors and independent contractors. Sole proprietors do not by law have to participate in the program. So if someone pays self-employment taxes, then they're not considered an employee and they can opt not to participate in the program. But they can opt in if they would like to do that. If they do opt in, they have to stay enrolled for at least 3 years, and they contribute one half of 1% of their self-employment earnings, so at the same rate as all other employees who are in the program. A sole proprietor who also has employees, even if they choose not to opt in for themselves, they do have to register with Connecticut Paid Leave and remit contributions on behalf of their employees. And lastly, if someone receives a W-2, then they are considered an employee, even if they're the owner or an officer of the company, so they would have to participate. The second thing is who's an eligible worker under Connecticut Paid Leave. And this is why I was curious, if my assumption was right, that there are a fair number of part-time workers in the industry. So there are 2 different criteria in order to be eligible for benefits. And the first is a minimum earnings criteria. So the worker has to have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters from 1 or more covered employers. If you have a part-time employee and they work for another covered employer and they don't meet that $2,325 from you, but they do when they combine the wages from their other job, then they would meet this minimum earnings criteria. Just for illustration's sake, for claims that are being made now for the time period of January 1st through March 31st, we're looking back at the 4 quarters that you see in green. So 4th quarter of 2020, and then quarters 1, 2, and 3 of 2021. Quarter 4 of 2021 is not being considered currently. Once we shift into 2nd quarter, then we'll be looking at the full year of 2021 for that eligibility criteria in terms of minimum earnings. And then the second criteria is that the employee has to be currently employed with a covered employer in Connecticut, or if they're not employed, that they were employed in the 12 weeks immediately preceding their claim for benefits. And of course, if they're a sole proprietor, they must have opted into the program. One thing to keep in mind is this is not something that you as the employer have to determine. We at the Connecticut Paid Leave Authority will make that determination with the data that we have from Department of Labor and other sources. But I do want you to be aware of what this criteria looks like. The next important thing to know is what do the benefits look like? So workers who earn minimum wage receive 95% of their base weekly earnings. For example, if you have someone who, for the sake of the math that I know in my head, if you have someone who works 40 hours a week, making $13 an hour minimum wage, they're earning $520 a week. They would receive 95% of that. So they would be looking at a benefit of $494 per week. Workers who earn above minimum wage, there's a different benefit calculation, which is fairly complex. So I don't go through sort of how it works. But we do have a benefit estimator on our website where someone can go and they can plug in their pay period frequency and how much they earn, and they can see an estimation of what they might be eligible for. For most cases, an eligible worker can receive up to 12 weeks within a 12-month period. It's obviously dependent on what their healthcare provider deems is necessary for themselves or for the person they're taking care of. So if the doctor says you need to be out for 4 weeks, that's their maximum amount of time, but there are up to 12 weeks available in the course of a 12-month period. The exceptions are that with family violence leave, it's only 12 days of those 12 weeks that can be used for family violence leave reasons. And if there's an employee who experiences incapacitation during pregnancy, she may be eligible for 2 additional weeks, which would bring the total to 14. Of course, some businesses do offer paid time off. So just want to talk about how paid leave benefits could intersect with employer provided benefits. One thing is that one of the main changes to Connecticut FMLA that went into effect in January is that employers are not allowed to require their employees to use all of their PTO in order to have income replacement during FMLA any longer. They can require them to use everything but 2 weeks. So if you have an employee whose doctor says they need to go out for 4 weeks and they have 4 weeks of PTO, you can require them to use 2, but they have to be allowed to hang on to those other 2 for use later on in the year if they would like to do that. If they don't want to do that and they want to use all of their PTO, that's fine. But if they say they want to hold on to 2 weeks, then you have to let them. So in scenario 1, if the worker has no PTO, or if they only have 2 weeks and they don't want to use it, they would be eligible for the full amount of Connecticut paid leave benefits starting at the beginning of their leave, because they're not receiving anything from their employer. In scenario number 2, if the worker has PTO that's equal to their regular pay, that would cover their entire leave, then they would be fully compensated by their employer and they would not receive any Connecticut paid leave benefits. In that case, they would still have that 12-week, up to 12-week allotment to use later on in the year if they wanted or needed to. And then we have scenarios where there's a combination of benefits. So in scenario 3, if our worker has PTO that's equal to their regular pay that will cover part of their time out on leave, their Connecticut paid leave benefit would not start until after they stopped receiving the PTO from their employer. And then in the last situation, if a worker has PTO that will cover part of their pay, can receive both the Connecticut paid leave benefits and the employer provided income replacement concurrently, they just could not receive more than 100% of their normal wages with the 2 combined. And then we'll now talk about the implementation of the Connecticut Paid Leave Act. So contributions, of course, the worker contributes half of 1%. It's based on their FICA wages, and it's capped at the Social Security contribution limit, which just went up this year to $147,000. The employer deducts that one half of 1% from payroll and remits it quarterly, as we talked about earlier. And at the Paid Leave Authority, we receive and reconcile contributions and process over or underpayments and can impose penalties for noncompliance. The Department of Labor comes into play because they can make the determination on whether or not employers can take catch-up contributions. So right now, for example, from January 1st through March 31st, the Department of Labor has said that any employer who needs to can take an additional 1% deduction to make up for missed contributions last year. So if there was a business that maybe didn't start taking contributions until partway through the year, and now they're behind in where they should be, only until March 31st, they can take 1.5% total. So the 1% plus the statutory 0.5% in order to try to catch up. But once April 1st rolls around, it would revert to the 0.5%. And then to take anything additional, that business would have to get permission from the Department of Labor. Now, on the claim side, we really have tried to make it very turnkey for employers in terms of any paperwork. So there's very little in terms of paperwork that the employer has to do. Here's how the claim process works. The worker, of course, should notify their employer that they're going to take time off and that they're going to apply for Connecticut paid leave. We always encourage this to employees. We don't want it to come as a surprise. It should be a conversation that they're having with you. We ask them to submit their application in a timely fashion. And what we mean by that is 30 days in advance if the need for leave is foreseeable or planned, and as soon as possible if it's an emergency leave or an unplanned leave. They can apply either through our website or by calling AFLAC directly. AFLAC is our third-party claims administrator. When they do that, AFLAC will let them know what kind of documentation they need to provide based on the type of leave that they're taking. They then collect that documentation and return it to AFLAC. One of the pieces of documentation is called an employment verification form. And so this is the one form that employers do need to fill out. The employee would fill out their information and then give it to the employer. And it's about 1.5 pages long. The things we ask for primarily are the typical work schedule, any other income they might be receiving in terms of, some companies have a short-term disability plan and things of that nature. When you complete the employment verification form, you'll return it directly to AFLAC. There's a fax number and an email listed right on the form. So you'll send it right back to AFLAC. It doesn't go back to the employee. And then beyond that, what we advise is that you would, of course, notify the worker about your PTO policies or short-term disability. If your company does offer that, each short-term disability policy is written differently. Some say that they're the payer of last resort. So that's something that is dependent on whatever your policy says. At the paid leave authority, we first will look at whether or not the person who applied is actually eligible based on that earnings and employment criteria. We will review all their documentation, and then we will approve or deny the claim as appropriate. When the claim is approved or denied, the employer will receive a communication from us, either email or postal mail, depending on what they specified as their preference on the employment verification form. Obviously, if it's denied, it'll say that this person has applied and has been denied. If they're approved, it will state the type of leave that they're approved for, the start and end dates of the leave, and the weekly benefit amount that they'll be receiving. We calculate and pay the benefits directly to the employee, either through direct deposit to their bank account or what's called a stored value card, which is a prepaid debit card. We monitor the ongoing claims, investigate potential fraud, and impose penalties as appropriate. If someone is denied a claim, they can do two things. They can either request a reconsideration from us, where we would go through and look at all the documentation again and see if a different decision is made. That would primarily be maybe someone was missing a document and we had said, okay, we need all your documents in by such and such a date, and they didn't get their medical certification in, for example, because their doctor was away and they couldn't get it on time. So something like that, they can request a reconsideration. If they don't want a reconsideration, or if they're again denied, then they can go to the Department of Labor and file an appeal. Next, I'll talk a little bit about FMLA. And again, stop me at any point if you have any questions at all. So FMLA, again, is that job protected piece. Are you covered under FMLA? So to be covered under federal FMLA, and federal FMLA is not changing. These are the same rules that have been in place. So for federal FMLA, an employer has to have 50 or more employees working within a 75-mile radius in order to be covered. Government entities of any size are also covered under federal FMLA. Under Connecticut FMLA, this is a big change. Federal FMLA now applies to almost all employers with one or more people working in Connecticut. And then you can see who is not covered under Connecticut FMLA. This reflects the same entities that are not covered under Connecticut paid leave. But this is a big change because prior to this year, only businesses with 75 or more employees were subject to FMLA. So now it's pretty much all businesses, as long as they have one or more employees working in Connecticut. Employee eligibility under FMLA. So on the federal side, again, this has not changed. The criteria are 12 months of employment and at least 1,250 hours of work. In Connecticut, this has also changed. The employee is eligible for job protection after 3 months of work, and there is no longer any hours worked requirement. So with FMLA, the employer makes the eligibility determinations. With Connecticut paid leave, we at the Paid Leave Authority make the determinations about eligibility. But for FMLA, it really is a conversation between the employer and the employee, which is why it's so important to know what the changes are that went into effect. The length of job protected leave has also changed under the Connecticut laws. So federal was and remains with 12 weeks in a 12-month period, with the exception of up to 26 weeks for military caregiver leave. The Connecticut timeframes now pretty closely reflect the federal timeframes. So Connecticut now offers up to 12 weeks in a 12-month period. Connecticut also has that 26 weeks for military caregiver leave. And then the addition is that there's the additional 2 weeks potentially available for incapacitation during pregnancy. And again, the Family Violence Act, Connecticut Family Violence Act, is up to 12 days in a calendar year. So this is just a side-by-side that shows what Connecticut FMLA was like last year and prior and what it looks like now. Again, we went from 75 or more employees in order to be covered by Connecticut FMLA to 1 or more employees. Previously, it was 12 months of employment and 1,000 hours. It's now 3 months of employment with no minimum number of hours worked. Connecticut previously offered 16 weeks in a 24-month period and now offers 12 weeks in a 12-month period. And again, the employer previously could require their employee to use all of their accrued PTO in order to have income replacement during their leave. Now the employer does have to allow the employee to retain up to 2 weeks of their accrued PTO if they would like to do that. In terms of FMLA claims, so the worker ideally should notify you 30 days in advance if it's a planned leave. They would submit their application directly to their employer and provide whatever the required documentation is directly to their employer. The employer should have an established policy, including rules about PTO usage. So what I mean by that, for example, is if your company sort of breaks up leave into vacation time, sick time, et cetera, if someone is taking caregiver leave, can they use their own sick time for that, or do they have to only use their vacation time, for example? The employer would need to process the leave requests, monitor the leave usage to make sure that the time allotted does not exceed what's available, manage the return to work. As I mentioned at the beginning, the Connecticut Paid Leave Authority does not really have anything to do with overseeing FMLA, but I think by now you can see that it would be really hard to talk about Connecticut paid leave without also talking about FMLA. The Department of Labor oversees Connecticut FMLA, and they have a new landing page they've developed that has all of the new regulations as well as the applications, the different forms that you might need to give to an employee. It's sort of in the middle of the right side of the slide. It's the ct.gov/DOLUI/new FMLA guidance. And then Department of Labor also investigates any complaints regarding the denial of FMLA claims. And then on the federal side, the Federal Department of Labor provides the regulations and investigates claims for federal FMLA denials, et cetera. Here's a flow chart that kind of explains what this process looks like when someone applies for FMLA. So the worker notifies you that they need time off from work. One important thing is that they don't have to say FMLA. If the reason they're telling you they need to take time off seems like it could be a qualifying reason, so they say, my spouse was just diagnosed with cancer and I need to take some time off to help get him or her to chemotherapy treatment, something like that. Even if they don't say FMLA, that should sort of trigger this process of going through to see if they are eligible for job protection. The employer will determine if the worker is eligible for Connecticut FMLA, and they have 5 business days to do that and provide what's called the Notice of Rights and Responsibilities, another document that can be found on the DOL site. This is not the leave approval, but this is the employer determining if the person has a qualifying reason and do they meet the eligibility criteria, which is that they've been employed for at least 3 months with you. Then the employer will tell the worker what kind of documentation they need, whether that's medical certification, military orders, adoption documents, whatever it is, depending on the specific type of leave. The worker has 15 calendar days to provide all those documents. If they tell you they're having a hard time getting them, you should give them a reasonable time extension. Once you have all the documents in hand, you have 5 business days to review them and then to notify the worker of the decision as to whether or not they are going to receive job protection under Connecticut FMLA. When you let them know if they're approved or not, you should also tell them if they have to use their PTO, when and how they need to call in, and if they need a fitness for duty before they return. And then the worker will tell the employer when they take their FMLA leave, and the employer will track that to make sure that it doesn't exceed the approved time. It's pretty straightforward if someone's going to be out for a continuous block of time, where it becomes really important that the worker identifies that the time is FMLA is if they're taking intermittent leave, where they are taking different time off that's not necessarily on a regular schedule. And when this might come into play is if you have someone who has a chronic condition like Crohn's disease, or they suffer from migraines, for example, they might have intermittent leave because they have flare-ups and they can't predict when those things are going to happen. So if they call in and they say, I'm having a bad episode, I need to take 4 hours off today, they would need to identify that that's their FMLA leave so it can be tracked appropriately. And then lastly, when the worker returns, they are returned to the same job they had before they went on leave. So that means the same terms and conditions, same pay, same schedule. You can't take someone who previously worked the 9 to 5 shift and tell them they have to work the 11 to 7 shift, for example. And if they were out for their own serious health condition, they might have some restrictions, in which case you should see if there are any reasonable accommodations that can be made. Lastly, just a couple of other laws to keep in mind when you're talking about job protection. So in addition to federal and state FMLA, there's also workers' compensation, of course, for covered on the job illnesses or injuries. That provides not only job protection, but also potentially income replacement. And then there are 3 other laws: Americans with Disabilities Act, Pregnancy Disabilities Act, both of which apply to businesses with 15 or more employees, and the Connecticut Fair Employment Practices Act, which applies to businesses with 3 or more employees. And for those 3 laws, leave may be considered a reasonable accommodation to make for someone. So to the resources that I mentioned earlier, we have, these are all downloadable on our website. We have an employer toolkit and a human resources toolkit that go into more detail about all of the topics that I've just talked about. We also have several documents that can be downloaded and shared with employees that explain sort of the nuts and bolts of the paid leave law. We also, our website has a ton of information at ctpaidleave.org. We have, I would say at this point, probably a couple hundred frequently asked questions. We do not have a call center, but we do have a contact us portal. And so if you have questions that are not answered on the website, you can write into the contact us portal. You can identify if you would prefer to speak to someone instead of emailing, and then one of the contact center specialists would call you to talk through that concern or issue. And then again, the FMLA side of it, for Connecticut at least, you can find all that guidance on the Department of Labor landing page, which is the new FMLA guidance page. All right, so
wow.
Let's have a discussion. What are your questions? I know you probably feel like your brain is going to explode.
That's, I mean, Jessica, that's a lot of terrific information. Wow. Bob, are you still on the call?
Hey, I'm
oh, hi, PJ.
I've just been on the phone. Sorry, it's been ringing.
No, that was a cute picture. So Jessica, I'm wondering, what are like the most common mistakes that an employer will make with the paid leave?
I mean, I think one of the biggest things, and this is not necessarily just on the employer, but on the employee as well, is not understanding that FMLA and Connecticut paid leave are 2 separate things. And thinking that if an employee comes and says, oh, here's my employment verification form, I'm applying for paid leave, that they then think they automatically have job protection, and they don't. Unless they go through that process of applying to the employer, they don't have job protection. And so obviously getting the benefits is great, but you still want to have your job to come back to after whatever that circumstances is resolved. So I would say that's probably the biggest thing that people run into.
And now this applying to, you know, as few as 1 employee is huge, because most of our members, you know, have maybe 2 or 3 locations. They don't employ a ton of people. So I think in their mind, they're thinking, oh, I'm a very small employer. I don't need to be knowledgeable on all of this. And now they absolutely do.
They do, absolutely. And one thing that we're really advising is that businesses make sure that they have a written attendance and leave policy, because you don't want to try to be scrambling to come up with a policy when someone comes and tells you, right? So you really want to have that in writing, in terms of, you know, if there's PTO available, do you have rules about the usage for that? What kind of, when someone tells you they're going to go out on leave, or do you want them to put it in writing? Can they send it in a text message? Can they just walk into your office and tell you? Kind of what's your process look like? And that will really help streamline it when someone comes in, because there will already be sort of a guideline and an expectation of what should happen for both parties.
Right. And in all that information you just provided, I think you had like a mock of something like that they could use, right?
So we don't have specific policies that people can kind of copy and paste, but I think that with all the information that you'll receive in the deck I'm going to share with you, I think that it would be, you know, fairly easy for someone to kind of pull pieces out and put together their policy. Another resource is we have partnered with the Connecticut Small Business Development Center through UConn, and they're actually doing a series of webinars about paid leave as well. But I know that they do offer free business consulting services. So for someone who maybe doesn't have a policy and is wanting to put one together, that can be a really great resource, and they would likely be able to help with that.
Okay, terrific. If you could get me a contact there or a link, I'll get that up on the site also.
Absolutely.
Yeah. PJ, what strikes you about all of this information?
So a couple things, and I apologize if you covered this, but really important as I've been doing more and more of these, and I'm really excited that our members are active and engaged. Jess, I know may not be the largest corporations, but we're really important in the fabric of communities, and we are often a first entry point for many employees when they come into work or flexibility. One thing you should know is, which I think is a really positive, they have retained AFLAC to do all the processing. I've actually called them, Jess, a couple of times on behalf of people. So again, no disrespect to our state government, but there's a perception that it's not as responsive, helpful. I think you'll find that office, and I think they moved like 150 people here, Jess, right? And
correct. Yep.
So they're really good. So when you call that number, again, that's after a claim's been filed, right? That's less about topics, but more when there's an actual issue. They're really on top of things. And
yeah, that's one of the key reasons that our CEO chose AFLAC, is that this is what they do. This is their industry, right? So they have it really streamlined. They have best practices in place in order to, you know, move things along as quickly as possible. I will say right now we are experiencing a really high volume of claims, and a lot of those are COVID driven, which is why we're trying to do a lot of education on the fact that, you know, simply having COVID doesn't necessarily qualify you. But right now we're looking at a turnaround time of 10 to 15 business days once everything has been submitted, once all the documentation has been submitted to AFLAC for the decision to be made. And if someone does contact, you know, through the call center or through emailing through the portal, they're receiving a response within 5 business days maximum.
And so that maybe we make that clear, Suzanne, to the members. Hey, when you have a question about the program, you call the authority. Am I correct on that, Jessica?
Yes. Yep.
Yeah.
Any sort of, I don't want to say generic, but sort of, you know, how does this work? Or, you know, I want to take bonding leave. How long could I apply for? Things like that can come to the authority. But once someone has filed a claim and they have specific questions, then they would want to go directly to AFLAC.
Good. Yeah. And then that's right. And the claimant. So that was one point I wanted to make. And I think a lot of this, so some companies have adopted plans, correct? I've seen those where they have internal plan of operations. Am I using the right term?
Are you talking about instead of the public plan?
No,
oh,
no,
okay.
Meaning policy.
Yes.
Some of these big companies, corporations where they've done, you know, we don't have human resource departments. Many of our members are family owned. What can they do? They're not going to adopt a policy per se, or do they have to? I mean, I don't know if you covered that. Do they have to have something in writing internal in their filing cabinet?
So, 2 things on that. One thing is the human resources toolkit that I pointed out, and that can be downloaded from our website. When we created that, we specifically created it so that the person who, you know, is the head of human resources at a huge company could use it, and the person who is, running the business, doing the scheduling, hopping onto the line to fill in when someone calls out sick, so that that person also can equally use that as a helpful resource. So that's one place that can be really, really helpful.
Okay.
In terms of coming up with a policy, I mean, I don't think it has to be anything super elaborate. The idea is just to communicate to your employees in whatever way, whether that's through an email or, an internal memo or whatever. Yeah.
Okay.
Just to let them know that, hey, we just don't want people to come and say, oh, I'm applying for leave. And then it's like, it puts a lot of pressure on everyone to try to figure out in that moment what the process is. So just so that people can have something to reference, if they know that something's coming up, they can say, okay, let me take a look and see what my employer is going to ask me to do for this. So Suzanne, I'm thinking maybe we get a draft template out to every member. Would you be willing to just look over something, Jess, that we're going to, because again, I think that's how most of our members would do it. Either send an email or post something.
And Jess also suggested the group at UConn, right, as a resource.
Yes.
Small Business Center. Yeah, they're great if you get through to them and you get the appointment and you get the person.
Process.
Take a little bit of
process.
That.
I do have, I can dig it out and send it to you. I do have a letter that we put together just to help employers communicate with their employees about paid leave, which is a little different than what you were talking about, but I could send that over. That might be helpful just as like a first point of communication to say, hey, there's this new law and sort of here's what it's all about and here's where you can obtain more information about it.
Yeah, that would be great.
I think we'll get one shot at it, right, Suzanne? And maybe we do it on our monthly meeting where we say, okay, everyone should look at this, send it to your employees or post it. And if we have everything in that, I think it'll be helpful. We
do also have a workplace poster, which I can send you the link for. That's also on our website. And that I think that can also serve as sort of the notice, right? That has all the details about how the program works and what employees need to know about it.
Mm-hmm. So another thought is most of our members, Suzanne, use payroll companies, right? A Paychecks
or they're so small that they're
literally writing the books.
Spouse does it, or their bookkeeper does it.
Okay, so could we include that in a Jess, would it be acceptable to hand them that document with a pay, once a year or something?
Yeah, absolutely. We also have like paycheck inserts and things like that for people who might be actually doing like physical paper checks. We have some documentation that we've put together that can be handed out in that way. And it's also digital. So if someone was, they could email that out to their employees as well.
That's great. Yeah, this is terrific information. Michelle, are you still on the call?
Yes, I am. I'm listening in.
Okay. Can you think of anything from your standpoint? Any questions for Jessica?
No, not per se, but we did have an employee when we did own the washes in Connecticut who got hurt in the fall, but now he's been away from us and hasn't started with his new employer yet because he's been on leave. How would that work? Because he really hasn't been able to get back to work.
Did he get hurt at work? Is it a workers' compensation?
He did not. He got hurt at home mowing his
lawn. So it really would be dependent if he met the minimum earnings and the employed within 12 weeks, right? So like say he got hurt in December and he hasn't been able to go back to work. As long as he met that 23, 25 minimum earning criteria, if he's still out of work, he could apply for paid leave. If it was more than 12 weeks ago or 12 weeks before January 1st, then it would be sort of out of that time frame of being able to apply.
Okay. The company who bought us called yesterday actually regarding him, and I said he really needs to speak to somebody at the Connecticut Paid Leave Act,
Yeah, and that's one that I would advise definitely having him or the company write into the contact us center. And again, it's just a matter of being responsible with our finances, that we don't have a call center. I know people often get really upset about that, but it's like something like $5 million a year to operate a call center. So it's just more efficient to have the contact us portal. But again, the agents are really great about calling someone to talk through if they want that, and they reply within 2 business days.
Okay.
I'll tell you how positive my experience was. Again, it's very unlike calling Department of Consumer Protection
or DMV.
Well, DMV is actually running pretty well these days, I have to say. In their defense, they've actually gotten a lot online, but
we're small and mighty. I think there's like 30 of us at the Paid Leave Authority. We're you know, but that allows us to be really, really nimble. So like, for example, I manage all our social media. People write into me through social media with a question or like, hey, can you check on my claim? I take that, I get it right over to AFLAC to try to get them some information. So we're trying hard to be as responsive as possible. And we're trying really hard to support the small businesses, because we know they are the ones that really need more of the education and support, because they don't have, you know, a human resources department with 50 people behind them. So we want to make sure that everything is very easily accessible for that group. We have a page on our website specifically for small businesses as well.
That's great.
Excellent. Excellent. Bob, did you have any questions?
No, I'm good. It was great.
I mean, this is great. And like I said, great information that we will get on the website. We'll get blasted out. We'll get all the links, you know, up and available to people. Just a wealth of information, Jessica. Thank you so much.
You're welcome. My pleasure. Like I said, I'll send you an email, Suzanne, and I'll put links to a whole bunch of different things. We have some videos that might be helpful that can be found on our YouTube page. So I'll send you everything, and then you can sort of decide what is most useful.
All of it up there.
Jessica, what did you do before this? You're basically...
I was in the radio industry for 15 years. I worked for a big radio corporation, and I worked down in Bridgeport, and then I moved over here to New London, which is how I ended up in this eastern part of the state.
That's great. I mean, and you really are starting an insurance company in a sense. This is a startup insurance company. You did a great job. Now I know why you're so good at presenting. And
thank you. I appreciate it. It was great to be here. And please, if after you share this information out, you have more people who come forward and say, hey, we'd really like to be able to do like a a deeper conversation, just let us know. Totally happy to come back and do something again with you.
Terrific. Awesome. Anybody have anything else for Jess?
No, that was really good.
All right. Thank you again, PJ. Thanks for setting it up. And we will be in touch.
We'll talk to you, Bob, Michelle.
Thanks, everybody.
Thanks, everyone. Have a great day.
You too.